Hello, everyone. Welcome. I'm Tom Zuber. I'm the managing partner of Zuber Lawler. Zuber Lawler is a law firm with locations across the country. We've been in cannabis since 2006, representing some of the biggest brands in global cannabis in respect of their higher stakes M&A, other corporate deals and financing transactions, IP, regulatory work, litigation and investigations. We also do an awful lot of employment work in the space. Welcome to our Cannaployment webinar, Best Practices of Wage and Hour Compliance in the Cannabis Industry, presented by FlowerHire, Greenleaf-HR, and Zuber Lawler, LLP. I'd like to start with the boring disclaimer. The opinions expressed of the individuals here and any companies associated with these individuals are not legal advice, do not comprise legal advice. We don't encourage the use of illicit drugs. Consult your healthcare provider and attorney regarding the use of cannabis for medicinal or to address legal questions. Nothing in this presentation creates an attorney or fiduciary relationship. Please seek the advice of relevant professionals. That said, I'd like to present my esteemed panel. I'm going to go ahead and introduce my panelists by name and then ask them to say a few words about themselves. Jason Desentz, managing partner of FlowerHire. Jason, do you want to tell us a bit about yourself and about FlowerHire? Welcome.
Sure. FlowerHire is the #1 cannabis recruitment and HR advisory service in the industry. And we have a lot of different clients we work with all across, from the MSOs all the way to startups. My personal background, I have over 20 years of HR experience, having been a chief human resource officer, both outside of cannabis and in, and have seen a lot of things inside cannabis, and hope have a really good time today in answering some of those questions.
Thank you, Jason. And next we have Beatrice Runyan, AVP of Client Development at Greenleaf-HR. Beatrice, tell us about yourself and about Greenleaf.
Hi, great. Hi, good morning, good afternoon, everyone. As Tom said, I'm Beatrice Runyan. I work for Greenleaf-HR. We are a PEO, professional employer organization in the cannabis industry. And I personally have my MBA and 2 HR certifications and over 20 years of HR experience in both internal HR as well as in the PEO space.
Great. And last but not least, my colleague, Michael Carlin, an associate at Zuber Lawler. Michael, can you tell us a bit about yourself?
Yes, hello, everyone. It's a pleasure to be here. I am an associate at Zuber Lawler. My practice is focused on labor and employment law. I represent employers from a wide array of issues, from wage and hour to internal investigations and litigation and arbitration of employee claims, such as Fair Employment and Housing Act claims in California, Title VII federally, discrimination claims, harassment claims, and retaliation claims. I also do a substantial amount of employer counseling and developing policies to comply with the always changing legal landscape in this field.
Wonderful. Thank you, Michael. And so we're going to go ahead and begin the webinar. I'd like to start by pointing out that, again, Zuber Lawler, the professionals here on the panel, I've been in this space for a long, long time. And the cannabis industry is a bit peculiar because some of the basic ABCs of compliance and attention in general are overlooked or when it comes to management of cannabis businesses. And it really is, I think, a function of probably in some part the history of cannabis. Cannabis is built on a foundation of an illicit industry, and this legalized industry still has, I think, the remnants, the memory of that illicit history. And for some reason, that tends to inform the industry with a bit of flippancy, and that results in, well, lots of problems, including litigation. So this is to us, we think, a timely webinar. It seems like the cannabis industry has progressed, has flourished in some regards, and also has met some extraordinary challenges, the illicit market and 280E and so forth. But also, as the cannabis industry has matured, we found that the number of violations that are being reported, the amount of litigation that's related to employment in the cannabis industry has really grown and continues to grow. So with that, let's go ahead and get started. On that notion that the cannabis industry really is quite special when it comes to employment and labor compliance, Beatrice, there's a notion that cannabis, because it's federally prohibited, federal laws like the Federal Labor Standards Act and other federal laws don't really apply to cannabis companies. Can you give us your thoughts on that?
Sure, I'd be happy to. So, there are some employers that may feel that way, but there's also been a lot of more recent legal decisions where the courts can show that cannabis companies aren't exempt from federal laws. So, a federal appeals court did rule in favor of the employee that worked for a cannabis industry and said that they could bring a claim for federal wage and hour violations, even though the federal law continues to say cannabis is illegal. So to give you a little bit more context about that, there was a ruling in 2019. It was for a security guard that worked for Helix, and they provided services for the cannabis businesses, and they were classified as non-exempt or as exempt from overtime laws, even though they worked more than 40 hours per week and only got a salary, didn't get any overtime. This employee filed a collective action against using the Fair Labor Standards Act against the Fair Wage and Hour statute, saying that he was misclassified as exempt. And Helix went back and said, no, they should dismiss the case, saying that they're not covered under the FLSA because they were working in the marijuana industry, which was illegal. So then that argument was rejected. Helix appealed it and tried to escalate it to the US Supreme Court, and they declined to hear it. And so basically the court ruled that cannabis employers couldn't both thrive in the industry and then also claim the illegal nature of their business shielded them from those wage and hour duties. And so it's noted, you have to realize that the Fair Labor Standards Act is meant to be very broad and remedial in nature, trying to cover as many workers as possible. So in the court's eyes, that also includes workers in the cannabis industry. And so the courts basically said 2 wrongs don't make a right. Just because you're violating one federal law doesn't give you the freedom to violate another federal law. And then
that's quite fascinating, Beatrice. It really is quite it goes contrary to intuition, right? Because I guess there's an assumption because you're operating in an industry where you're sort of I guess in the sense of compliance, you feel a bit like an outcast because you're not able to deduct certain portion salaries and so forth, things that don't cost of goods served, sold on your federal tax returns, but at the same time, you're expected to adhere to these to other federal laws, and that really is, I think, maybe that's part of what informs this flippant psychology that we often find in relation to compliance, including employment compliance.
And if you dig a little even further into that, even though this was in Colorado, and it maybe only affects, at least at that point, affected maybe just some of the surrounding states, but if usually Congress, will look and say, okay, if it works here, they're going to apply that same measure of the law in other states. So you want to they kind of look at it as it's not a novel, their novel defense didn't work. So don't count on it helping you, even if you're not in the state of Colorado or in other states, especially where they allow recreational sales versus medicinal. And so really it's more important than to focus your energies on avoiding the claim in the first place. Just assume that your business is going to be subject to the federal wage law, just like every other employer, because you also have to take into consideration, other state and local wage laws that wouldn't even be subject to this defense anyway. So it's just something to be mindful of, that even if you're not in Colorado, don't think that it won't apply to you.
Thank you, Beatrice. And so that's not necessarily great news for cannabis companies. The burden is even larger, weightier than perhaps previously assumed by some cannabis companies. All these federal laws relating to labor and employment, they still apply, even though you're not able to deduct anything but cost of goods sold on your tax returns as a function of federal prohibition of the cannabis plant. Michael, let's go to you next. How does wage and hour compliance in the cannabis industry differ from compliance in other industries?
Yeah, excellent question. So specifically as it relates to wage and hour, the cannabis industry faces similar issues as most other manufacturing or retail industries face. But I would say that the nature of the industry, as you touched upon, as being federally unlawful, and the cultural norms of the industry result in some interesting arrangements to attempt to counter some of the challenging aspects of the industry, especially in states with strict labor laws. That results in common industry practices that are just not consistent with the law in every jurisdiction. So I should say, one example is the use of independent contractors, not just at the entry level or manufacturing level of a company, but really in every level of the cannabis industry, all the way up to the C-suite, you see the use of independent contractor agreements. And these agreements are subject to pretty strict scrutiny as of late, and can result in claims by employees or by the Department of Labor, the state or federal Department of Labor, for claims of employee misclassification.
Thank you, Michael. Jason, without giving confidential information away, can you give some examples of wage and hour violations that were particularly harmful to cannabis companies?
Yeah, I mean, this is an age-old problem even outside of cannabis, right? Is classifying your people appropriately. First off, it's just good culture to pay people what they are owed, quite frankly. And I think when people try to skimp out on some of the cost aspect of it, it really does come back to hurt them. We've had a client who unfortunately got, someone filed a claim, same thing, and they got fined. And they had to not only pay back pay because of the overtime was not paid out, but they also had to pay the fine, which, you know, in some cases could just be financial. But with cannabis, people need to understand you could lose your license, and those are expensive. So it's, do you really want to, you know, save a little penny here just, you know, to lose a big license? I think people just need to pay the right, you know, fee as far as, you know, the wage for the employees. And it's just good business and good culture. You'll have a higher retention rate as well. So that's probably the best example I can give you. And we're constantly at FlowerHire helping companies categorize those and, you know, using the FLSA test to actually help them identify which jobs are exempt and non-exempt.
And Jason, we found that in assisting our own clients in this space, that it's important to focus not only on the fact that you'll have to repay some of the missing wages and the hourly compensation, but you're actually also potentially going to have to pay hefty penalties on top of that, particularly states like California, not exclusively California, but some of these states really are quite aggressive in those penalties. And then in addition, you may be exposing your license to some vulnerability there. So those are really quite hefty stakes here, and it's important to make sure that the audience members realize that. Michael, let's go back to you, please. What are some of the biggest areas of concern relating to wage and hour compliance for cannabis companies?
Yeah, so as I touched upon before, misclassification of employees as independent contractors is probably the most common. And for decades, most states had somewhat similar states for similar tests for establishing whether someone is an independent contractor. But a growing number of states have been using what is referred to as the ABC test, which is somewhat of a departure and usually much more difficult of a test to meet to find an employee, or I should say a worker, as being a true independent contractor. And so I'll just touch upon this test. The factors are three. Factor A is the worker is free from the control and direction of the hiring entity in connection with the performance of the work. And that's not only under the terms of the contract, that is actually something that's looked into is the actual facts and circumstances of the employee's work. Prong B is that the worker performs work that is outside the usual course of hiring of the entity's business. And that's the prong that is the most challenging, I think, for companies to show that they're hiring somebody who does work outside the usual course of the hiring entity's business. So for example, if you have a cannabis company, retail company, selling goods to consumers is kind of part and parcel of that company's what they do. And so if you're hiring independent contractors to do that, that is almost always not going to satisfy prong B. The last prong is that the worker is customarily engaged in an independently established trade, occupation, or business of the same nature of work that is involved in the contract for services with the organization. And so I think another way people get into trouble is they are looking for a worker to perform a specific task. They go find somebody who is suited for that. But the person's really traditionally an employee. They don't have a set up business. They don't have marketing. They aren't really putting themselves out there as, this, and it can be in any level of a cannabis company, from marketing to, like I mentioned before, executive services. And that's one other way that you see cannabis companies get into trouble with misclassification claims. It's important to note that there are several jurisdictions. So California, most noteworthy, is one of the kind of leaders in this, I would say, movement to make independent contracting more stringent and more employee friendly. But there's also a number of other jurisdictions that have moved to this test. And I think that we will continue to see other jurisdictions moving away from the traditional, what was referred to as the right to control test, and move to this more stringent test where you have to show that the worker is performing duties outside the course of the business.
Great, Michael. So those are quite a narrow set of parameters then. So it comes down to degree of control. The second prong is this duty, is this service provided by the would-be employee or independent contractor typical for somebody in that business, within that business? And then the third is, are they holding themselves out for other purposes aside from performing that one service for that one company? Is that correct? That's a summary of the three prongs there.
Right. And I should also mention that there are a number of, as with any law, there are a number of exclusions that you can potentially take advantage of. One common way to kind of get around the ABC test and go back to what we would refer to as the common law right to control test is if an organization, you're contracting with another business. There are a variety of other types of exemptions, artistic sorts of work, hiring people for that kind of thing. There's a number of different exemptions, so it's probably too much detail to go into all those at this time, but yes.
So to give an example then, Michael, it would seem to me by that definition, an example of someone that might be an independent contractor, again, noting for the audience, none of this is legal advice and there's no attorney-client privilege relationship here. If you have that retail cannabis company that you had mentioned, hiring somebody to build your website, that seems to me like that might fall within the boundaries of those parameters, right? Because that cannabis retail shop wouldn't have a great degree of control over that website design company. Two, that's not really what a cannabis company does. It's build websites. Certainly, it operates websites. It sells products on websites, but it doesn't build websites. And three, to the extent that vendor, that website design company, building company, is servicing other companies, is marketing themselves to other cannabis companies, then those three prongs are arguably met. But on the other hand, if you have somebody that's working part-time and they're actually serving as a sales rep on the floor of that shop, it would seem to me that based on that test, that it could not be considered an independent contractor in most circumstances, and would probably have been misclassified if that person were not categorized as an employee. Would that be fair? Again, noting for the audience, we're not rendering legal advice, but just to illustrate by example.
Yes, certainly. That's a great example. I would agree with that, and I would also say that the kind of classic example that the California Department of Labor at least gives is like the plumber. If you hire a plumber to perform services for your business, that plumber is not going to be under your direction or control, is going to be doing something that's completely different from your business and is in an independently established trade. So the closer you can get to those facts, the safer you're going to be.
Okay, great. Thank you, Michael. Beatrice, let's come back to you now. If a cannabis company determines that there have been wage and hour violations, how does one responsibly speak to employees at that point about the violations without creating liability for the company?
Sure. Well, I think the most important thing is for the companies to try to be as transparent as possible. Obviously, there are certain things that you're not going to be able to, share with the employees, but as much as you can, I think employees will value when their company is open and transparent. Address the issue. I mean, if it's going to be, known that there was a violation, or, depending on what it is, if it is, if it's a FLSA, or if it's a wage and hour, if it's a 1099 misclassification, address those issues, let them know what it was, what steps. I think it's very important you let them know the steps that you're going to be doing to correct the issue, because if it's someone that's misclassified, to Michael's point, if they have been classified as a 1099 and they really should be a W-2 employee, then explain to them why they are now being changed over and the reasoning for that. And then put some systems in place to prevent it from happening in the future. I think that you need to, address it to make sure it doesn't, happen again, especially if it's the 1099 type thing. You can look at it and say, for future similar positions, making sure that they are properly classified, along things like that. And really just communication is the key. I can't stress enough that really just keeping those lines of communication open with the employees, and just making sure that they understand that it doesn't look like you're trying to hide something or sweep something under the rug, just being very open and forthright with the employees.
Thank you, Beatrice. Very important type of conversation there. Jason, cannabis companies, of course, many of them do have both employees and independent contractors. And so we have a trickiness here that we're settling upon. What advice do you have for those cannabis companies? Meaning, what advice do you have for structuring workforces comprised of both employees and independent contractors?
Yeah, some of the things to think about first and foremost is really trying to understand what's the work the contractor is going to be doing first. If you really understand the scope of the work and the duration of that work, that'll help you understand whether or not it should be a permanent position versus a contracted position. In my experience, I have seen all kinds of crazy stuff, and it really usually comes down to saving cash flow. I'm going to be honest. It's about saving cash, bottom line, expenses, SG&A, and every time they get in trouble. I've not seen one person, once it does get escalated, not get penalized. And, and in some cases, I've actually even seen where a contractor has direct reports that are W-2 employees. That is a big no-no. And that is a huge red flag when, organizations try to do that. Again, it's really about the scope of the work that contractor is going to be doing. If it's going to be a long-term scope and it actually, the person is there acting like an employee, the whole outside of cannabis years ago, the old Microsoft case where, they had contractors and employees, and then they all got sued and they had to make them employees because they went to all their potlucks. They had the same badge. Nothing was different or differential between the contractor and the employee. But most importantly, having a contractor as a leader over W-2 employees is something I see quite a bit actually in cannabis. And our firm has really helped companies really think about the work, not the people, not the structure, but the work. And then you kind of build your organization based on that. And then if they meet kind of the temporary contracted needs, then you put them over as a single contributor usually, and that helps out the department or, however they go in. So just really understanding the scope of the work and, just open lines of communication and not afraid to speak up and let the leadership know, especially in HR, let your leaders know that this is going to get us in trouble. And, and it's not something that we advise. And, it's really, again, you don't get a lot of value out of it. Right now, cannabis is more stuck on culture, where companies and their employees, because Gen Z really cares more about the culture of the organization. And when they see stuff like that or hear stuff like that, it starts to create lack of trust. So with that being said, I would just encourage you to really look at the scope of work and then how you want to structure your org chart after that.
Thank you, Jason. Beatrice, the cannabis industry, all this talk about compliance is nevertheless fraught with meal and rest break violations. Of course, we know that. What are some of the best practices to minimize these meal and rest break violations?
Yeah, absolutely. There's a lot of practices that companies can look into doing is making sure that they're providing uninterrupted rest periods and meal breaks. Those are the things you really want to look at your state specific laws. I think that's the biggest thing you want to be mindful of, because some states, especially the things like, let's say, for instance, California, they have a law where, non-exempt employees, you have to have a rest period of 10 consecutive minutes for every 4 hours of work, or at least a major fraction thereof. And then if they work 5 or more hours in a day, they have to have a 30-minute unpaid meal period. So a lot of other states have very similar requirements. So first and foremost, be cognizant of if there are any state-specific laws that affect your organization, and then make sure you have good record keeping practices. Do you have a system for documenting meal breaks and rest breaks? Do you have a system to document if for some reason someone's meal break got interrupted? Let's say they were halfway through their meal break and got pulled off because they needed to, cover for someone else that was out. So making sure that you can document when they aren't able to take their, appropriate breaks, and that they get paid if they go back on the clock, that it was adjusted. It's not an, automatic time deduction for a meal break, that they get paid when they go back on the clock. So all of those things, making sure that the employees understand that they need to clock in performing any tasks, because I know there are situations where there have been issues with some organizations where they only pay once they start working versus the time to get dressed, to, do all, grab their necessary tools, whatever the case may be. Anything that can be tied to performing the task of the job needs to be paid. So making sure that there is a policy and practice in place for the employees, that they're clocking in before they start performing any aspect or any task that's related to the job. Just again, anything that's integral or indispensable to those employees' duties are considered work hours. And so they need to make sure that they're clocking in before that.
Very good note. And that's I imagine quite an overlooked function of employment compliance and labor compliance. That notion that if you're doing something that's in preparation for the job, that's directly tied to the performance of that job, that is oftentimes considered part of the job. Right. And needs to be compensated, and not compensating for that, not counting that as hours worked, that can lead to violations, right. is what I'm hearing. That's
exactly. Yeah. So for instance, let's say you've got someone that's either doing cultivating or manufacturing, and they spend time putting on or taking off, it can be on the back end too, if they're taking on or if they're putting on or taking off protective equipment, or in any other pre-work activities, those need to be time that needs to be compensable time. And so, or even if they're working in a facility and they've got it's in a distance from where they actually arrive to work, where the actual work is being done. So, all of those things need to be taken into consideration. Same thing for like a retail employee, if they, they need to be aware of if they're being covered, if they are allowed to take the appropriate paid and unpaid breaks, if they have to spend time, doing bag checks, other security measures, things of that nature. All of those things need to be taken into consideration.
Thank you, Beatrice. Jason, segments of the cannabis industry are notoriously resistant to compliance measures, even if those measures are known, whether generally or specifically. So on that note, once you identify best practices as a company, how does that company achieve buy-in with management and employees in the context of this notoriously resistant culture, if you will?
Yeah, that's a great question, because this comes up a lot, quite frankly, and it's really deals with how do you get them to recognize the significance of compliance. And the way in which I've seen it work, as well as practice it myself, is really data, is putting, showing them the why they should be doing or changing and structuring something like, wage an hour or, org planning, because, you got to remember the folks that are typically, it's a mixed bag of leadership in cannabis. You have people who came from the illicit market that started a company, never had been in corporate or a business and understand how that works. FLSA, they paid cash before that. Then you have, a lot of the professionals that are coming into this space and taking a lot of their former experience, including myself, from regulatory and that's what a lot of those companies are getting in trouble with is you have to really pay attention to the compliance, because it really is your foundation for the long-term success of your organization. And if you have that compliance foundation, it does tend to lead to less issues being brought up, less challenges on some of the compensation wages that come up. And more importantly, the culture feels like, okay, you care about me, you put this process in place. But again, when you sit in a room with all these leaders and they're like, why in the heck, Jason, should we be doing this? And then I just lay it out in a very, structured way, but simple, right? It could be 2 or 3 slides. If you do it this way, these are the things that are going to happen. But if you don't, here's the other things that happen. And a lot of times it could be monetary. A lot of times it's shut down your license. You could close a retail store if you don't have that. Well, that's your revenue, right? For a lot of cannabis firms. And or if you have to shut down the grow. Can you imagine shutting down the grow and you have all of that product in there and that happens? That's product loss. There's so much, I think, at stake with, compliance, that it's really important that HR leaders or whomever, when they take something to senior leadership, explain the why, and please have data to support the why, and then I think you can have more of a fruitful conversation regardless of where the leader came from, whether it was before illicit market or whether it's professional. As long as you have the data, that leads to discussion for change.
Thank you, Jason. And I think that's a great note. You want to scare them with data and a couple horror stories. And unfortunately, I think it does come down to that. And I will point out that if that's not something that management is ready to do, perhaps that means hiring one of our panelists, yourself at FlowerHire or Greenleaf or Zuber Lawler, an employment attorney at Zuber Lawler, to make that point. But I think that is a great note. And I do think it's important to recognize the obstacle that this culture, that this I guess resistant culture provides, puts in front of us, and it really is quite a substantial one. So thank you for that, Jason, very much. Michael, what are the typical consequences or penalties for non-compliance with wage and hour regulations in the cannabis industry, on that note of trying to scare people into compliance here? And I hope that that's received with some humor as intended. Go ahead, Michael.
Yes. So the most common penalties that you're going to see are back wages. When employees are not paid the correct wages, they're entitled to the amount that they should have been paid. Closely related to that is overtime pay. So when you, especially in California, if you're shorting people on, or not intentionally, hopefully, but if somebody's not taking the breaks that they should be taking and it's not their fault, it usually results in overtime pay needing to be paid to the employee. Penalties are also a big area of concern. The labor code has dozens of provisions that would require an employer to pay penalties. Some of these penalties, like waiting time penalties for failure to pay wages on termination in California, are payable directly to an employee. When an employer is presented with a claim prosecuted by a government agency like the Attorney General, the Department of Labor, there are additional technical, what I kind of refer to as technical penalties that usually are not recoverable by a private actor, by a former employee or current employee, but they may be payable if you are faced with a government action. It's also really important to note that in California, at least, the labor code here, section 558.1, provides that the owner, director, or managing agent of a company can be personally liable for wage and hour violations. So that means even if you took all the care in the world to separate your interests from the company's interests, you could still be on the hook for wage and hour violations if it's found that you that this was an intentional violation.
That's extraordinary, Michael, and I don't think that many folks are aware of that. So I want to make sure that we highlight that a bit. We're saying now that there's for an executive at a cannabis company if that executive knew of those wage and hour violations. There's potentially personal liability, despite the management of that company having taken due efforts to separate corporate interests from personal interests. That's what I just heard, correct?
Yeah, exactly.
Yeah, that's obviously that's pretty high stakes stuff. Thank you, Michael. Now, this is not really all doom and gloom. The good news here is that it really is not that expensive to address wage and hour compliance before the violations. It's expensive to address them after violations, but it's really not that expensive to address them beforehand. It's really, I think, more a function of organization and discipline and focus than it is a function of massive investments. The way that litigation is fed by massive investments of legal fees and consulting fees and so forth. So let's talk about that. Beatrice, it seems to me that one of the places to start is an audit. That's the first thing you want to do, is you want to take a photograph of where you're at currently, and the way to do that is with an audit. What are some of the best practices for conducting internal audits to ensure wage and hour compliance in the cannabis industry?
Yeah, Tom, you're spot on. You want to, again, prevent it before it happens. You want to make sure you have your systems in place. So some of the things that you want to look at from a best practices standpoint is, one, again, going back to knowing what is specific to your state specific laws, whether it's FLSA, even minimum wage for your state, if there's any other requirements or things that are particular for any state that you operate in. Make sure you're looking at any states where you have employees, not just where where the corporation is headquartered. You also want to just look at your current practices, see what you currently are doing and seeing if any of those need to be adjusted. You want to make sure, again, your independent contractors are misclassified. So you go through you make sure you do, the FLSA duties test and the salary test to make sure, some of that for the FLSA, but for independent contractors, that they don't fall under a 1099 when they really should be a W-2. So really just kind of making sure that everyone is classified correctly. They're also classified whether they should be exempt or non-exempt. And you also want to make sure about any overtime laws for any type of, if you pay by a piece rate work or any agricultural exemptions. So there's a lot of nuances that go into play with that. Also make sure you're paying correctly for any training hours, on-call time, any waiting time, making sure that you're enforcing your meal and your breaks, making sure that those are being handled properly. And also having written job descriptions. I know that a lot of times there may not be something documented, but if you can have written job descriptions that specifically say what this person's responsibilities are, then you have something to go back to and then make sure, and that will also help you then using those written job descriptions to make sure an employee is properly classified.
Thank you, Beatrice. Michael, do you have anything from a legal perspective to add to that?
Yeah, so I agree with everything that Beatrice said. I would also highlight that, in addition to reviewing the documents, the policies, the pay stubs, I think one important piece that a lot of employers may not be so keen on is actually talking to sample of employees to ask what their experience has been with meal and rest breaks. A lot of employers don't want to get into this, but trust me, you're going to want to know if your employees are saying that they're only able to take 20-minute lunches before the Department of Labor comes in and asks your employees what their experience has been in terms of how long their meal breaks are. I've seen clients get into that exact situation. And taking less than a 30-minute lunch break in a lot of jurisdictions can get you into trouble and result in fines and penalties being assessed.
Great. And so it's the employer's responsibility to make sure that those parameters of breaks are met. And that's an important note here. It's not enough just to leave it to the employees to take the breaks on their own. Okay, so Jason, let's come back to you for a moment. It's one thing to be compliant. But even that really is not enough, in the sense that you also need to prove it, and hence part of compliance is actually maintaining the records, right? So it's a bit of an identity equation in that way. But the point is that oftentimes in the cannabis industry, records are sort of given a flippant nod, and not really focused on it. And so as consultants, as attorneys, we know that we've gone into cannabis companies where we've been asked to help. And the first thing you do is you take a look at what's already there, and the records sometimes are not in an ideal state. And so can you tell us a bit about that? And I'm speaking specifically, of course, about the steps that a cannabis business should take to establish effective timekeeping and record keeping practices.
Sure. I mean, we get asked a lot through our HR audit, and one of the major things that we notice is record keeping is not consistent.
Yeah.
You know, and what I tell a lot of our clients is, you know, the cannabis industry it's unique in many different ways, but it's really unique in this way because each state has its own marijuana regulatory authority. And it's almost like when I was a global chief people officer, I had Germany, France, England, they all had different wage and hour things that you had to know. So too often when companies decide to go MSO, multi-state operator, they think the practice in one state is going to be practiced here in another. It's really important, one, you read those regulations first and understand what the state's going to require for various different types of, you know, documentation, but also where you store it and how you store it is really important, and being consistent. You know, you don't want to have one document or a wage and hour document, let's say, for example, in an actual file, paper file, but then also have it electronically. You have to ask yourself, why do I have it in two spaces? And does that cause a problem? So a lot of your HRIS or PEO firms have automated systems that can house all that information. And I would always recommend, if and when, do that. Where you would think in today's day and age, when everything should be paperless, it still isn't. And it's kind of surprising to me because I've been doing this a long time now. And I feel like that statement was when I first got into the 90s, we're going to go paperless. And here we are again, and we're still not. It's really consistency, and then, you know, having an ability to pull it pretty quickly. People don't realize a lot of those systems that you use have those capabilities. You can store documents in them. You can access them pretty quickly. You can give customized access to managers and leaders. There's a lot that can actually be done in these systems to protect not only you, but the employee. Because if an employee leaves and asks for their records, you know that you can go to a certain file. This is how they all are. I know which records to pull because they're consistent. And I took the time to set that up. It's really just spend the time. It doesn't take that long. Set it up, or if you don't, find someone like us, a professional, or you all, that come in and do an audit and kind of help you along the way. Because a lot of the issues we have is people just don't know where to start. I don't know where to start. It's all over. What do I do now? First, it's identify, right? And it's create a sense of urgency, because now you know you need to change because it could cause problems. And then you build them a roadmap. It doesn't have to be complex, but try to keep it automated would be one of my advice. And then try to keep it consistent. It's in one place. It's not in multiple places. And understand your local state marijuana regulatory authority.
Thank you, Jason. And Jason, you hinted at one of the big challenges of the cannabis industry, and one of the opportunities, which is the variation between states in areas, for instance, like compliance. So let's stay on that note a bit. Michael,
Sure.
What are some of the unique challenges related to wage and hour compliance operating across multiple states with different cannabis laws? And of course, we're speaking now to MSOs.
Yeah, so I would say the issue is, you know, the varying degree of the number of different types of schemes and requirements for state-specific payment issues. So, for example, the deadline to pay final wages. Some states require you to pay that at the time of termination, like California, if you're terminating somebody. Some states say that you can go to the next pay period. It's important to not just have like a uniform practice there and really get that nitty-gritty state-specific detail. Similar with meal and rest breaks. Some jurisdictions don't require specified time periods for or they require different standards than what you find in California. If you're operating a dispensary in Illinois. There are going to be different meal and rest break policies that you cannot have, I would not recommend having like a uniform policy across both states, because that is kind of like a recipe for misunderstandings and, in worst case scenarios, for wage and hour claims.
Great, thank you, Michael. Jason, let's come to you next. How can employers proactively educate their workforce about wage and hour laws and their respective rights in the cannabis industry?
You know, a lot of companies tend to be paternalistic with any policy. So meaning they think they know what you want and then they implement it. The best way to do it, and we said it earlier in this webinar, is to take a pulse check and, ask them. It's not going to hurt you to ask the employee, but once you get that answer back, it helps you build what I call your communication plan or roadmap for things like wage and hourly and any other policy, quite frankly, to really say, okay, we heard you. Here's some of the major questions we heard in this survey. Here's the buckets or the pulse that we got. And then directly either have multiple ways to get to the folks and your employees. A lot of employees today's day and age use their cell phone. They don't have a computer. They don't have anything other than their cell phone, my own son's included. So the way in which you have to communicate might be different as well. But a simple webinar, you can pre-record yourself and send it out to the entire organization. I typically like things like this to come from leadership as well, not just HR. Because if you get the leadership buy-in and you got a leader presenting possibly on all things, including wage and hourly, it tends to get a little bit more credibility. It's not just an HR police policy. So I encourage, one, have multiple media platforms on how you want to get it. Print form, you can still do that. We hand them out at the lunch breaks, or in the lunch rooms. We just have piles and set up. Like here's a new communication we want to hand out, or go to this site. We have the webinar it's quickly, you can we recorded it for you, or look, it's mobile friendly. You can watch it on your phone. So I encourage you to really think a little bit more broadly about the context by which you're going to talk about, but who is going to do it for you as well. The more leadership you get involved in these kind of situations and communications, the better it's going to be, and it'll probably stick better for the employees. Similar to an engagement survey, it's always one of the top 3 reasons why people are disengaged is their leaders don't communicate. Here's an opportunity for a leader to communicate, and I think I would encourage them to take that up.
Thank you, Jason. Beatrice, we spoke a bit earlier, staying on this notion of, I guess, education and prevention, about the fact that it really is not such a large investment to focus on compliance before violations as opposed to addressing violations after they've happened, including in the form of litigation defense. What are some of the resources and tools that are available to assist cannabis companies in maintaining wage and hour compliance, including before the violations ever happen?
Sure, there's a lot of resources out there, and I think if you look at even our firms, the panelists, we have a wealth of information. If you go to Zuber Lawler, there's lots of information, lots of resources, blogs, articles. If you go to FlowerHire, there's information. They're doing strategic talent management, comprehensive HR advisor services, lots of great resources for blogs, articles, Greenleaf-HR. We provide, HR, payroll, benefits, performance management, onboarding, all of those things. So there's a lot of information that's out there on just our 3 organizations where they will have resources, different blogs, all of those things that will make it kind of easy in one location. There's links to events that are coming up, future webinars, articles, law updates, all of those things you can have information for and not have to go to, Google 12,000 different websites.
Wonderful, Beatrice. And of course, we do advise our colleagues to take a strong look at what Greenleaf has to offer here, because it really does make a lot of sense to focus on compliance before violations happen as opposed to addressing them after they happen. Michael, are there any recommendations for addressing potential wage and hour compliance issues during mergers and acquisitions acquisitions in the cannabis industry. Even in these distressed times, there's still quite a bit of M&A activity, particularly from companies that have their powder dry, so to speak, and are able to take advantage of some of the distressed situations we're seeing out there.
Yes, very true. I would say when you're doing due diligence, you're going to want to be as stringent as what we were talking about when doing an internal wage and hour audit. Include a review of employee classifications, written pay policy, practices and policies, timekeeping records, employment agreements. And I think it's important to assess the financial impact of any potential violations that you find and factor that into a deal's valuation and negotiation. You can also negotiate for indemnities and warranties in a purchase agreement to protect against unforeseen wage and hour liabilities. The EDD also allows selling entities to obtain certificates to represent that they're current with payroll taxes. So you would want to also ensure that the transaction documents reflect that funds don't get distributed until after that certificate by the EED is issued.
Thank you, Michael. Any closing thoughts here from the panelists as far as what you'd like the audience to take away with them from this panel?
I'll jump in. I think the most important thing is to just kind of overarching, going back and making sure you're aware of what is specific to the states that you operate in. I think that first and foremost is know what is pertinent to you. I think second to that, and then making sure you're compliant with, FLSA, 1099. Those are the couple of big key things. And I think the last but certainly not least is that communication, to what Jason was speaking, is having different ways and keeping those lines of communication open, making sure, know what the culture is in your organization. As Jason spoke to, you've got the Gen Z, you've got lots of different generations in the workforce today. And so making sure that you understand how you're communicating with them, various ways. Some people still like email. Some people want a Teams chat. Some companies might have Slack channels, the good old fashioned memos and posters. But I've found in my years of doing HR that you have to communicate in multiple different ways. You can't just send out an email or have a video recorded and expect employees to remember that. I think I think you have to repeat something 7 times before it sticks. And so having multiple, send out an email, then reinforce it with a Teams chat or a Slack message, and then put a flyer up. So I think just in general, just being open and communicating with your employees of what the policies are and making sure you're consistent with how you're administrating those.
Thank you, Beatrice.
I could jump in, next. Honestly, what a great opportunity we have. It's a new industry.
Yeah.
I always say, let's not repeat the sins of the past other industries. Beatrice talked about there's so much information out there. Ask. If you don't ask, you're not going to get. So you're not going to, it's okay. Because trust me, we talk to clients all day long. And when they do ask, it's almost like they're looking around like, are we the only ones doing this? And the answer is no. So it's okay, but if you don't ask, you won't know how bad it really is and how, one of us can help you. And really, and we can also give you where to start. And that's the other problem. I think folks think internally that they can't fix it. So I'm not just going to look away. So just ask and, and look to one of us if you don't know or can't research it. But gosh, we have an opportunity to not repeat the sins of other industries. Let's use this opportunity to make this the most elite industry and not have to think compliance will be just a reflex. And we can actually focus on the growth and profitability, quite frankly.
Thank you, Jason.
And I'll finish it up. So thank you again, everybody. I love those comments. I would just add one, if you don't have written policies, it is vital to work with a professional to develop written policies. 2, to the extent that you have those written policies, you want to make sure that your employees acknowledge receipt of those policies with a signed document. And then 3, I think it's important to consistently review every year wage and hour policies in particular. These are the wage and hour policies, state-specific policies in particular, have a tendency to change frequently. And so you don't want to be left in the dust with an old policy that doesn't work anymore.
Great, thank you, Michael. We have time for one or two questions if the audience has them. I have one question here in the Q&A chat box. Thank you for the presentation. With the high turnover rates and the wide range of roles in the cannabis industry, accurate classification of employees is a big challenge. Can you share some additional best practices or methods for maintaining accurate employee classifications, especially in the context of the rapid growth and the frequent hiring and oftentimes turnover in the cannabis space? And that's an open question for the panel, I take it.
I can start off on that. So I think it's a good question. It's a challenge that a lot of businesses are facing in the cannabis industry. So accurate classification, both not only with independent contractors, but also one thing we didn't touch on so much is exempt versus non-exempt employees. I think having a well-defined current job description is critical. I think we mentioned that a little bit earlier. And not only having that written policy or that written job description, but also making sure that consistently stays updated, because as economic realities happen, as turnover happens, things are going to, roles are going to bleed into other roles. And I think it's important to make sure that, for example, if you have a non-exempt employee, or I should say, if you have an exempt employee, so let's say, there's 3 usual exemptions when under the Fair Labor Standards Act and under a lot of state laws. The administrative exemption is a common one that you see companies use to pay their employee salary. If you have somebody who's an administrative exempt employee, making sure that their duties, their day-to-day duties actually align with that job description, and that they are doing at least 51% of their usual tasks fall into that role of exempt employee duties. As soon as you get into an employee having, a little bit more non-exempt work, then you can get into trouble with regulators and on wage and hour claims, both through litigation and through the labor department. So there's a lot of the one problem with wage and hour in particular is that there are so many different angles that you can find liability, and being able to kind of minimize that with appropriate documentation policies is, I think, the key here.
Thanks, Michael. I'll take the final word here. It's difficult, I think, when you're facing something that's this large, which is something like wage and hour compliance in an industry as transient and as emergent as the cannabis industry, and as challenged as the cannabis industry. And I think the place to start is with a snapshot of where things are currently. So to that extent, if you're wondering how to get started here, you're saying, oh, well, maybe I'm not as focused on compliance, or my company hasn't been as focused on compliance as perhaps it should be. The place to get started, I think, one of the places to get started is one, to speak to a professional, like one of the professionals on this panel, but also I think an audit, right? Finding out where you stand, taking a look at, okay, here's my organization today. Here are the wage and hour compliance regulations that need to be adhered to, and what's the gap. And I think starting with that gap is a good place to go, and that gap I think can inform perhaps the rest of the conversation going forward. I want to say thank you to my esteemed panelists here. It's always great to see our friends at Greenleaf and at FlowerHire. Michael, good to see you, and I'll be seeing you, I'm sure, quite often. Thank you very much, everybody, for attending, and we greatly appreciate the time, and also very excited about the cannabis industry and where it's going, and with a bit of compliance, it can really go a long way toward avoiding massive investments into remedying violations after they occur. Thank you so much for attending, and hope to see you out there soon. Bye.